Breaking news. Welcome to today's headlines. Nnamdi Kanu demands 25 billion naira compensation from Buhari government. Nnamdi Kanu demands 25 billion naira compensation from Buhari government. To my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. Nnamdi Kanu has demanded 25 billion naira compensation from Buhari government. News Online report that Nnamdi Kanu, leader of the indigenous people of Biafra (IPOB), has demanded 25 billion naira compensation from the Nigerian government. Nnamdi Kanu urged a federal high court sitting in Umuahia, Abia State, to compel the federal government to compensate him with 25 billion naira over his arrest and repatriation from Kenya. He explained that the money was compensation for the physical, mental, emotional, psychological, property and other damages he suffered as a result of the infringement on his fundamental right. The IPOB's leader claim was contained in a suit filed before the court by his special counsel, Aloy Ejimako, where he stressed that his arrest in Kenya was illegal. Ejimako disclosed that he would be leading a legal team to demand that Justice Evelyn Anyadike-led court enforces Kanu's fundamental human right. A statement by Ejimako titled, Nnamdi Kanu approaches Federal High Court, Umuahia to enforce his fundamental right against unlawful expulsion, reads partly today, 25 March 2022. On behalf of Mazi Nnamdi Kanu, I am leading a team of lawyers at the first hearing of the fundamental right enforcement suit I had brought before the Umuahia Division of the Federal High Court. The matter lies before Justice Evelyn Anyadike. The suit is sui generis and primarily aimed at redressing the infamous unlawful expulsion or extraordinary rendition of Nnamdi Kanu, which is a clear violation of his fundamental right under Article 12 of the African Charter on Human and People's Rights. In addition to the rendition, I am asking the court to redress the myriad violations that came with the rendition, such as the torture, the unlawful detention and the denial of his right to the fair hearing required by law before anybody is expelled from one country to the other. You will recall that on 19th January 2022, the High Court of Abia State determined that portion of violation of Kanu's fundamental right that occurred in 2017, even as I had made claims that bordered on rendition. The court declined jurisdiction on grounds that rendition, being related to extradition, lies within the exclusive jurisdiction of the Federal High Court. So, this instant suit is as a result of my considered decision that a fresh action before the Federal High Court will be the best route towards addressing this matter of rendition or unlawful expulsion and its legal impact on the prosecutorial powers of the Nigerian state. To be sure, the extraordinary rendition of Nnamdi Kanu triggered illegal injuries that cut across multiple jurisdictions both inside Nigeria and abroad. There are now new legal and even diplomatic issues that must be addressed in the United Kingdom, Kenya, the United Nations and the African Union. And within Nigeria, the rendition has expanded the matter far beyond the realms of the trial that lies in Abuja. Kanu is seeking the following reliefs: a declaration that the arrest of the applicant in Kenya by the respondent agent without due process of law is arbitrary, and the respondent enforced the disappearance of the applicant for 8 days, and their refusal to produce the applicant before a Kenyan court for the purpose of applicant extradition is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right against arbitrary arrest to his personal liberty and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. A declaration that the detention of the applicant in a non-official secret facility in Kenya and the torture of the applicant in Kenya by the respondent agent is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right against unlawful detention, torture, and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. A declaration that pursuant to Article 12(4) of the Charter, the expulsion or extraordinary rendition of the applicant from Kenya to Nigeria by the respondent without a decision taken in accordance with the law of Kenya is illegal, unlawful, or constitutional and amount to infringement of the applicant's fundamental right to fair hearing and not to be expelled from a state party to the Charter except by virtue of a decision taken in accordance with the law as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. To my dear listeners, now we've come to the end of our today's news. Please do drop by at the comment section and let's know what your view is all about. Thank you for listening.